we do bring in immigration updates. Along with me, my business partner, Emily Neiman. Emily, what do we have today?
Yeah, today we want to talk about Attorney General Ken Paxton in Texas, who has decided that he has the power to investigate North Texas companies. He's asking about 30 of them to provide documents and information, alleging there's some sort of ghost office situation going on there. So we'll talk about what exactly is happening and why, and what that means for H-1B workers in Texas and beyond. We'll also talk about the prevailing wage regulation that is expected to be finalized soon. This will impact H-1Bs as well as H-1B1, E3, and PERM labor certifications. The wages may go up by 20%. How workers and employers should prepare for that and what they need to know. Then we'll talk about the continuing issues with H-1B holders being laid off, L1 holders, other visa holders as well, but what options do they have? Filing an H-1B transfer, H-4, F-1, F-2, B-2, or what about the compelling circumstances EAD? You don't really hear about that anymore, so we'll give you the latest on all of those options. And lastly, traveling on OPT or STEM OPT in 2026, why it is risky and why we don't recommend it right now.
Emily, with regards to the Texas Attorney General, he's been an Attorney General for a long period of time. And what's the story about him? I mean, I know that it's not because he wants to do something, it's because he's contesting the elections.
Yes, this is all about the election.
He's been an Attorney General for a while. And
exactly. If you've been an Attorney General for so long, why is this just now coming to your attention? It's only because he's running in the Senate against longtime incumbent John Cornyn. And these two guys are just in a race to the bottom when it comes to immigration, proving they're pro-Trump, proving they're pro-MAGA, proving they're anti-immigrant as much as they can so that they can make it past the Republican primary and then eventually maybe be elected as our representatives in the Senate for the state of Texas. So this is all just a political stunt. I don't even know if he has the power to look into these things. Obviously, you know, immigration is federal law. If anyone is going to be looking into issues, it should be Department of Homeland Security, USCIS, Department of Labor, not the state of Texas.
Well, let's look into some of their allegations. When I look into his thanking for some Spanish lady there, and he's thanking that lady, saying that thanks to that particular lady, and that particular lady, and I've seen some of the videos, YouTubers that are complaining about these consulting companies, that they are taking the American jobs, and then they are saying that there are no jobs. I'm a bit confused. What are they telling in their media, except that they hate Indians? That's for sure. I can see that. They hate Indians from the core. They hate it, and they see that they're really biased against particular races, no matter, even I've seen them interviewing, are you a citizen? Okay, how did you become a citizen? How did you come into this country? These kind of statements that I've seen in those statements, and they are telling that these Indians are taking the jobs. Then they are telling there are no jobs when they go into the, what they call it as ghost offices. It's very confusing to me. What is the idea that they're telling other than that they tell we hate Indians? What is that they're telling? That Indians are taking their jobs, or there are no jobs?
Right. They're claiming that, you know, they're going to these office locations, and when they're visiting, there's no workers there. There's no H-1B workers there. Well, that makes sense when the H-1B worker is working at the client site, and the LCA specifies exactly where the H-1B worker is going to be placed. And so if the LCA mentions the company location and the end client location, and the H-1B worker is at the end client location where the job actually is, that worker should not be expected to be at the company's office. And these companies operate that way. That's their line of business, is to hire H-1B workers that are placed at another company, at an end client site, working remotely from home sometimes, but usually at the end client location. And so if they want to find this H-1B worker, they can simply go to the end client location that's listed on the H-1B petition. Doesn't mean there's no job there. So and again, if they're claiming that the job doesn't exist because these offices are not staffed with anyone, it's a ghost office. Well, which is it? Does the job not exist, or are we taking jobs from American workers? You can't have it both ways here. And they're just looking for any and all opportunities to show their racism against Indians, particularly, and anti-immigrant sentiment on top of that.
Emily, a couple of things I have advised recently, that people are also coming and knocking the doors of the apartments. Though my advice to them is to check whether they're the government officials. If they're not government officials, I want them to say three words. No hablo español. That's it. And if they keep on asking the questions, you keep on telling no hablo español. That's the best way to respond. And this is happening in Texas, so everybody knows what I say. What that means is that no hablo español. That's the best answer for you guys. If the person is not a government official, is asking the question, they are not trying to do any good thing for you. They're going to try to insult. They're going to insult your race. They're insult to where you're born. They are going to insult. They call where you come from is a shithole. That's the words that they have used in those videos. So they don't give any respect to you, your family, to your country, or the work that you do. So don't try to appease them, though. The best solution for you to get out from them is just use the word no hablo español. That's the best thing. No hablo. No matter what language they speak, your response will be no hablo español. That's just the way to get away from that. Anything else, Emily? We'll go to the next topic.
Next up, yeah. So prevailing wages, we know that generally every year they update on July 1st, and generally they've been increasing every year. But why might they increase more than usual this year based on this proposed regulation?
Well, one thing is that this proposed regulation may become law very soon. So in general, though, what we have seen, the salaries or wages going up by about 20%, especially for the H-1B occupations. We are expecting, though. So if, for example, your H-1B is for renewal, and if the company cannot meet the wages requirement, they will not be renewing your H-1B. So you need to look into it, sometimes maybe changing the jobs to get a better salary, or probably change. For example, if you're located in New York and San Francisco, the salaries are very high. But what if it is in a remote place in Texas or Kansas, the salaries may be low. Maybe you should move your location to a smaller location where the wages are, reasonably fair, where you can get your H-1B. So definitely, I want you to take into consideration of all these things, because it may become law by end of this year. That's what I'm expecting, Emily. What do you?
Yeah, I was anticipating that they might try to time it along with when the prevailing wage update on July 1st every year. I'm not sure if that's going to be possible now. I think there's been some shakeup with the DOL leadership not too long ago, so that might be causing a little bit of delay. So it might happen later in the year, but I do think it is going to happen this year. And once it is published, it should take effect within 60 days typically. This was done before during the previous Trump administration, and that ended up not moving forward. It was implemented. We had to submit a bunch of prevailing wages, wait for those to be issued, and then the regulation was vacated in the court. DOL had to go back and reissue all of those prevailing wages in around October 2020 to use the old calculations. And then it's been a fight ever since for them to come up with a logical calculation for how we determine prevailing wages. They do these surveys every year of different companies and different jobs and different locations, and come up with kind of what the bell curve looks like of the salaries. And then they just divide it into 4. And that's level 1, 2, 3, and 4, without having any kind of tying of that particular dollar amount to the amount of education or experience that a particular employee might have. So that is one of the bad things about our current system, but they haven't come up with anything better. And their new plan is just to change where those 4 cutoffs are and make it all higher, which again does not tie directly to any kind of proof of what a normal person's education and salary and experience is for that role. So we're not really solving anything. We're just shifting everything upward. And I do think that that's going to be coming into play sometime this year. So if you're up for renewal this year, you might want to file it now rather than later. And as Rahul said, be prepared for the event that that does go into place and your company might not be willing to file the extension. You do also have private wage surveys as an option. In the proposed regulation, they did specify that they're going to be looking at those much more closely than they have in the past. So that might raise more scrutiny, but it might be the only way to get the H-1B petition filed if the company is not willing to pay the DOL wages.
If you get laid off, what are the options if you're an H1B, or if you get laid off, what are the options? This question comes very frequently. There's a lot of changes that are going on in the employment-based immigration right now. So I'm going to give you the options in the order of preference. Obviously, if your I-94 is still valid, if you lose the job, you have 60 days to find a different job and file another H1B. That is definitely the best option. And there are some people that are working for big companies and now they got laid off. They asked me the question, can I join the consulting company? The project is only for 6 months or 1 year. Absolutely, that's the best way to do it. As long as the project is there, it's a genuine company, you should file a H1B transfer. Absolutely not a problem. That is the best option that you can do, is find a job within 60 days and then apply for the H1B. The second option would be definitely if you have an H4 plus EAD option, choose for it. If your spouse has an I-140 approval, H4 plus EAD is an option. If the spouse does not have an I-140, but the spouse is an H1B, H4 is definitely a very good option. People, I don't know why they hesitate using the H4. They ask me the question, Rahul, if I move to the H4, can I move back to H1B? Absolutely, you can. If you have not used up the 6 years of H1B and now you are actually moving into H4, you can move back into H1B at any point of time in the next 90 years. Why not more than 90 years? I don't think so. You'll be alive by that time. In the next 90 years, you will be able to move back to H1B without subject to the H1B lottery, without subject to the $100,000. You can move back to H1B if you have a job. So H4 is an option you should consider. If the H4 option is not there, you can consider F2 option. If your spouse is an F1, you can move to F2 option. You can also, and if the F2 option is not there, you should consider F1 status though. I know that about 2-3 months ago, there are some lawyers who told that B2 is the best option. I'm one of that lawyer, blame me for that. I know that it did cause some pain to a lot of people. Previously, they were approving B2, and while the B2 is pending or when the B2 is approved, when we are applying for change of status to H1B, we had no problem. But from February onwards, it is becoming a big problem because there's no premium processing on B2. So F1 is definitely an option. You can go back to school. You can re-educate yourself. There are some things that you might be missing. Even I've been experiencing 30 years. I may have some things missing in me. I can go back to college and educate myself. Maybe it's technology. Maybe it's law. Maybe it's some relevant field. So definitely, maybe it's office management, maybe it's the computer skills. All those things I can still learn. So you can go back to school and learn more skills. So that's F1 is an option, F2 is an option. And B2, if you can't do any of these things, B2 is an option. It's a very dangerous option as it's becoming. Emily has written a very nice article. B2 has become a trap for the people where USCIS told us to file a B2, and now they are denying from B2 to H1B. They're issuing a notice of intent deny for the H1B. They're issuing a notice of deny for B2. So B2 is the last option that you can think about. I mean, we can always file and fight it out later on. If you don't have any H1B option, H4 option, F1 option, F2 option, then B2 may be another option. You may even consider compelling circumstances EAD. Now, from B2 to come back to H1B, it is really, really, really very tough right now. It used to be very easy before January of 2026, but now it's very tough. Now, compelling circumstances EAD is an option where you can, if you have an I-140 approval, you, your spouse, and your children also are eligible for compelling circumstances EAD. You can file for the EAD. You normally, if your circumstances are, if it's compelling, like you have a loan, children are going to school, or you have a car loan, mortgage, or so, you can apply for compelling circumstances EAD if you have an I-140 approval. They normally grant an EAD for 1 year. Now, here is a catch point for the compelling circumstances EAD. Once you go to compelling circumstances EAD, you cannot switch back to H1B. You cannot switch back to H4. You cannot switch back to H1B because it technically is not a status. Now, to do that, you will have to go outside the country. Now, the problem with the H1B is if you go outside the country, then you are subject to $100,000 fees. So when you are evaluating all these options, though, please take into consideration, I've written an article 2 weeks ago, then you can take a look into that, all the different options whenever you want to, or consult an immigration lawyer when you're picking what is the best option for you. But obviously H1 is the best option, H4 EAD, H4, F1, F2, or B2. These are the options and compelling circumstances in that order.
Yeah, I think with the the B2 and the compelling circumstances EAD, you now need to think of those as kind of a dead end. They are an option and they do buy you some time, but right now there's no coming back from them to anything else. As you mentioned with the compelling circumstances EAD, there's no change of status after you get that. You have to exit the country in order to get back into a non-immigrant status. And if the non-immigrant status you're going for is an H1B, then that's going to trigger the $100,000 fee. Even if you've had an H1B before, even if you have an approved I-140, it's considered a new H1B. Consular processing means that you are going to have to pay the $100,000 fee, which no companies are doing. And as you mentioned on the B2, we are getting a few B2s approved if there's no H1B filing and you have very strong documentation. Most of them are getting an RFE. But if you're trying to switch back to H1B, you need to wait until the B2 gets approved and then make sure there's enough time left on your B2 stay to then file a change of status back to H1B. That's the only way that it could possibly work now, since they've changed their tune about allowing you to change back to H1B while the B2 is still pending. Last topic before we get to the questions is F1 students. If you're on OPT or STEM OPT, should you travel outside the US and why or why not?
First of all, we're telling everybody not to travel outside the United States right now if you are an OPT or STEM extension, because there's a lot of screening going on when you're trying to enter back into USA. They're looking into what jobs you have done. For example, I will tell you that an OPT, you can be on a paid internship or unpaid internship, it's also allowed. But when the CBP officer is asking, they are unable to understand unpaid internship and they are returning back. They're saying that, oh, you did not work, you were not employed on OPT, 90 days of unemployment will kick you out of it. So we're going to send back to your home country. Please note that any time period you spend outside the country, though, will be considered as unemployment. We have seen a lot of people, especially coming from Abu Dhabi airport and also from Chicago airport, being thrown out. They were not allowed to come in because of this instances, though. We strongly recommend, highly advise people not to travel outside the country while you're on F1, while you're on OPT, while you're some extension. Do not travel outside the country. That is our strict advice right now. If you don't follow it, you may face a lot of problems for it. Anything else, Emily?
All right. No, I think we can go to questions. Rocky says, in the current company, I got my priority date January 2016. My current role is staff software engineer, and sounds like he's up for promotion to software engineer manager role. And he wants to know, do I need to file the green card process again? So I'm assuming you have your labor certification approved and your I-140 approved, but have not yet filed your 485. This is going to be really dependent on the attorney that your company hires for the process. There are some attorneys that say that you need to start the process over again because it's a new position. There are other attorneys that take the stance that over time, career progression, normal career progression does happen, and it does not invalidate a labor certification or approved I-140 petition. So it ultimately is going to be down to which camp your employer's attorney falls under.
A lot of people asking with regards to the biometric screening, though. Right now, this is applicable for the green card applications that recently USCIS has started on April 27th, and citizenship application. Yeah, definitely it may slow down the 485 application and 400 applications. We have seen people who have gone for the interview, they're getting biometrics there at the time of the interview. Definitely that's one thing. But most of the people whose applications are pending may be called for the biometrics. So don't be panicked about it if we've been called for the biometrics. It's definitely one of the delay tactic done by the administration. This question is in response to Santosh Kumar's YouTube question.
Priya says she applied for AOS for herself and her child in February, and then later filed for her spouse in the EB1A category. They're in H1B and H4. And spouse now wants to go to India, but there's no advance parole. And she wants to know, what will the impact be if the green card gets approved for the H1B holder, but not the H4 while the H4 spouse is outside the US? It's a very risky situation. Should not travel in that situation. Wait to get the advance parole, because if the H1B holder is no longer in H1B status because they're now a green card holder, the H4 holder has not received the green card yet because it was filed a month later, there's no way for the H4 holder to come back. There's no H4 status. So you'd have to convert the adjustment of status into consular processing, which is going to take an extra year or two for that to be processed, and you'll be stuck outside the country the entire time unless there's some other visa category that you can come back on. But if you do that, that might also abandon your spouse's 485. So lots of bad things can happen, so definitely not recommended.
User DG7 from YouTube is asking that you told not to travel. Can I travel to Abu Dhabi and Qatar and bring my wife and halfway through and then bring my wife and kid? Absolutely not. Because that's exactly, you're traveling outside the country, though. I mean, there are business class. If you really are concerned how comfortable your wife and your kid is, buy a business class ticket to me. I mean, it's very costly, those. But it's probably worth rather than you going outside the country. I mean, they're very luxurious. And, only one time I ever traveled in the business class was really luxurious. And believe me, you can even sleep there and there too. So if you are, you can afford sending your wife and kid in a business class. I do not want you to travel. Abu Dhabi airport, that's the worst airport you can go to anyway. So I even advise that maybe your wife and kids should not be coming through that airport. And a child is your citizen, but I do not advise people who are non-immigrant visa people to come in Abu Dhabi airport. And even if you're a green card holder, be very careful before you come from Abu Dhabi airport.
Siva Kumar says, working for the same client and employer for the last 4 years, nothing has changed in the role or job duties. My employer has filed multiple I-797 renewals, but messed up with the LCA wage levels. This is becoming an issue now. USCIS did update the I-129 form as of April 1st, where they now require on the form the employer to specify the minimum education required for the position, the field of study required, the minimum years of experience required for the position, any special skills required, and any supervision that the worker is going to be doing. They're taking that information and comparing it to the wage level that's selected on the LCA, and some employers are not aware of how those answers on the I-129 form impact the prevailing wage level, and they need to be selecting the correct prevailing wage level, and this is causing notice of intent to deny, denials, notice of intent to revoke. So it's very important, yet again, for you to make sure when you're filing your extension that you file it early, file it in premium processing so that if you get any kind of issue raised about wage level or prevailing wage or minimum education, or there's a site visit and there's a discrepancy between the years of experience mentioned on the petition versus what the end client says and what the employer says and what you say, you have time to potentially withdraw and refile or figure out how to correct your status by traveling and then refiling. There are options generally when you file early and get a decision early. But if you wait till the last minute and file and your I-94 is expired and then you get one of these kind of RFEs, you have very little options at that point.
Singapore Chena from YouTube has this question. Is there anything called unemployment benefit to get the green card? And my answer is yes, there is. And what do you mean? People are unemployed and they can get a green card? Yes, we call that as visa lottery system. As long as you have a high school degree and you don't belong to top 10 countries, which excludes India, China, Mexico, and other things, you will be eligible to apply for the visa lottery. And you can apply for, even if you are here in the United States or outside the country, if you don't belong to top 10 immigrating countries into the United States, you are eligible even if you're unemployed, as long as you have a high school degree and you don't have any criminal history, even you're unemployed. I call that as a green card for unemployed. And it exists, guys. It's called visa lottery system. I am not telling a lie. It is really the truth.
Gayatri says, well, on H4, can we invest in shares? Asking since this may yield income. Yes, you can purchase stock, you can purchase shares, you can be a shareholder of a company, and you can earn income from your shares of a company while you're on H4. That does not impact your status at all because you're not considered to be employed by that company, even if you are earning income from the shares that you own of that company.
Can I do the stock trading, Emily? Sell them, make money, and then next day I can buy the same stock? Is that considered illegal for the H4?
Nope. You can definitely do that.
One other person is asking the same question with regards to, can I buy a real estate and rent it out? As long as it's one real estate property or maybe two of them, you're fine. But if you're crossing that though, definitely you may want to check with an immigration lawyer to see if you're crossing that particular lane though. Now, with regards to the Airbnb, answer is no, because your day-to-day involvement is there in Airbnb. But if it's just a lease though, where you're just leasing out the facility, leasing out your apartment, leasing out your house, we don't have any problem. That too, up to two properties. If it's more than two properties, I definitely want you to speak with an immigration lawyer.
Abhishek says the processing time mentioned online is around 6 months for I-129s, but no one is getting a decision. Why is there consistent delay? Yeah, that's the Trump administration. That's the Trump effect. That's exactly what we saw last time around. They keep raising the fees and not providing any better service, slowing everything down in the name of national security, in the name of extreme vetting. We have the new form version, so there's more review of the information in the petition. There's more security checks. Now they're doing all these biometrics for people if they've had any kind of past law enforcement interaction. You can only imagine that all of that adds up to delay, and it is on purpose. So don't delay in filing. File early, file in premium, get the decision before your current status expires.
Wife is an H4 EAD expiring in October 2028. She got H1B approval in November 2025, approved until November 2028. Can she switch back to H4 and use the EAD? Absolutely, she can. There are two ways to switch back to H4 though. One, she can apply for the H4 again. However, there is an easy way. We call it as a margarita switch. All she needs to do is fly to Mexico. When she comes back, she shows the H4. A lot of people ask the question, oh, she doesn't have the H4 visa stamping in the passport. I already knew that. That's the reason it's called automatic revalidation. When you go to only to Mexico and Canada and not to India, only Canada and Mexico, you're coming back within 30 days and no stamping, you can come back. Oh, will they not ask questions that you had a H1B, why you want to move to H4? No. There's nothing wrong in saying that I want to be with my husband. I want to have a flexibility on my H4 EAD so that I can be very flexible as compared to the H1B. Absolutely nothing wrong. Will they ask about your husband's job? Of course. Will they ask whether your relationship is good with your spouse? Of course. They should ask those questions. They will ask those questions, and you would be fine with that. I don't think so. You'll have any problem.
Babu says applied for H1B, H4, and H4 EAD extension altogether in premium in April 2025. Got the approval for the H1B and H4, but not the H4 EAD yet. What are my options? I'm assuming April 2025 is the correct date and not April 2026. Litigation is really your only option to try to get an adjudication of the EAD because they're not required, according to the settlement agreement, because it expired. They're not required to bundle them and approve them together anymore. A lot of times they still are, but if they're not, litigation is really the only route.
Me and my wife is a green card, but my son didn't. He just he's 14 now. They took his biometrics. How long it will take? Should take about 2 to 3 weeks, but if it's taking longer than 3 weeks, though, you can contact Stephen Brown in our office, or you can send an email to info@rnlawgroup.com, and you can file a lawsuit so that his green card is approved soon. There is also something called F2A, but I don't think so. You should consider that. Since your priority date is current, I would go in suing the government and getting the green card faster.
Naveen says I'm on H4. My visa stamp on my passport is expiring July 2026, and the same is the I-94 validity. But the principal applicant I-797 is expiring September 26. What can I do to remain in status? You need to file 2 extensions. One right now to extend from July to September, and then another one with your spouse to extend everybody beyond September 2026. Otherwise, assuming you have your new passport, you could potentially travel and return to get a new I-94 that gives you the full validity until September 2026 instead of July 2026. But no matter what you do, make sure you do something before July 26th.
Can the H4 EAD person work as can they have an Airbnb? Absolutely. H4 EAD, you have work permit. It's unlimited. There's no restriction on it. So you're good with the Airbnb if you have a H4 EAD.
Stanislav says, I was waiting for my L1B extension for 9 months. 3 months before the end of the 240-day grace period, my company upgraded to premium processing. Now we got an RFE. It looks terrible. Is it just retaliation? I think we can say that this is across the board for L1Bs, L1As, I-140s, and the EB1C. This is a common target during the Trump administration of making these cases harder, making the standard higher, asking for a lot more documentation. I got basically the exact same thing in one of my cases this week, not pending for 9 months. We filed it in premium processing, but I got a 20-page RFE yesterday asking for everything but the kitchen sink. And even though we submitted tons of documents, so it's just the new standard right now. It's definitely not retaliation.
Miles has a very interesting question. I already have an H1B approved under consular processing. If I go to stamping in 2027, does it trigger 100K rule? Depends on when the H1B has been filed. If your H1B has been filed before the executive order start date, even though you are going for stamping in 2027, the H1B was filed before the executive order, the $100,000 is not applicable for you. However, Miles, if you are in United States, though, on a different non-immigrant visa, though, I would advise instead of going and stamping outside this country, you might as well, you can still apply for the change of status here in the United States, and you will still not be subject to $100,000 fees, and you still don't have to go to the lottery system if you are in the United States. If you're outside the United States, since your H1B has been filed before the new executive order effective date came in, you can still file, you're not subject to the $100,000 fees.
Krishna says, could you advise whether applying for the H4 EAD and an H1B amendment for a location change would expedite the H4 EAD approval process? It can, but it's definitely not guaranteed. We do see many times that when you file an H1, H4, and H4 EAD in premium, All three do tend to be approved together. The biometrics photo for the H4 EAD is becoming problematic, so you may want to consider filing everything in regular processing, wait until the biometrics are done, and then try to upgrade. That did work for me recently in getting all three approved together, but it is completely up to the officer. There's no rhyme or reason to it. They don't have to do that, but that's one of the best ways to at least give you the best chance of having it happen.
Justin has this question that H1B is expiring in August 2027. When can I file the extension? Technically speaking, about you can file within the span of 6 months, not before 6 months. That means in January of 2027, you can file an extension. If it's an amendment plus extension, though, you could file it anytime. You can file it right now. But if it's only extension, then it has to be in the span of 6 months before it's expiring, which is, in your case, will be January of 2027.
Srinivas says, my wife has valid H1B visa stamping. However, she has an H4 and is in India right now. If she secures a job from a new company and they file her H1B, will they need to pay the $100,000 fee? Even USCIS doesn't know the answer to that question right now. So it comes down to their guidance that they put out made it a little bit unclear what they mean by visa. Do they mean the visa stamp in your passport, or are they referring to the H1B petition? And so it's a little bit unclear if someone who's outside the US has a valid visa, therefore they don't need to go for stamping, but they're still filing for consular processing. Does that trigger the $100,000 fee? A lot of people that filed for those kind of cases in December received RFEs on that issue. They replied back explaining that according to the guidance, the way it's worded, it should not apply. Those cases are all on hold. They're not approving them because USCIS doesn't even know how they want to handle those situations. So I would not recommend filing right now.
Question, give me 1 second.
Poonam says, is this a right decision to switch from L1A to H1B in today's scenario? Maybe. H1B obviously has issues with the $100,000 fee, so you have to be careful to properly maintain your status, because any issue with your status that comes up in a later filing could trigger the $100,000 fee. That's supposed to end in September, but we expect it to be extended. The main benefit of an H1B over an L1A is job portability. With an L1A, you are tied solely to your company and you have no way to transfer your L1A to any other company. So if you lose that job, your only choice is to exit the US, unless you want to, change a status to F1 to study or something like that. But there's not a way to switch to any other type of work visa in that situation, versus an H1B. If you lose that job, you do have the 60-day grace period where you can find another employer. So there's a little bit more flexibility there, but the H1B does have its own issues right now as well.
Amardeep has this question from YouTube. Very interesting question. He has an EAD from the adjustment of status, and if he loses a job, he feels that he may not get another employer who's willing to sponsor an H1B. Is it safe to be on an EAD? Now, under your conditions, though, definitely if you're not having an employment period is very dangerous for 485 application. So if I were you, I would join on the EAD. There are some risks for you if you let go H1B and you are on EAD. There are some, if the 485 gets denied, then definitely that may create a lot of trouble for you. Now, there are some risks by maintaining the H1B also, because I've seen a lot of FDNS visits, and if some problem occurs there, it might kick into the 485 application too. So definitely, when I was in a non-immigrant visa status, when I had an EAD though, I let my non-immigrant status go and started using the EAD. So it's up to you how you are going to do it. But this is what. Now, why does all the lawyers tell now that to maintain the H1B and EAD? Not all the lawyers. I did not. Why do some lawyers tell? Well, that's how they make the money, I guess, because if you maintain the H1B, and EAD, we make more money. So take a guess what you want to do.
CRIVGRI says, if my H1 to B2 change of status is still pending and the 6-month end date is May 20th, and I get a new job with a start date of June 15th, can I file the change of status back to H1B, and would I accumulate unlawful presence from May 20th onwards? Not an ideal scenario, because your change of status to H1B will be denied because you were not in status on the day of filing with a start date of June 15th. You're not maintaining your B2 status between May 20th and June 15th. Best case scenario for you is first get the B2 approved and then immediately file the change of status to H1B with an immediate start date. And all of that has to happen before May 20th. Otherwise, pretty much anything you try is unlikely to be successful based on what we're seeing right now.
Do you still advise people not to travel outside the country, or is the situation improved? Definitely did not improve. I'm not expecting situation to get improved until this Trump administration is gone. So if you're anticipating that it's going to get better, then I don't think so that it's going to happen. Trump is going to be the president for the next 2.5 years at least. So until that period of time, definitely I'm not expecting anything to change.
Jesus says, for Venezuelan currently waiting on an L1 extension valid until July 31st, with the current pause, is the better option to go through consular processing or file the extension within the US? Well, consular processing means you've got to exit the US and hope that you get a visa stamp, which is probably unlikely considering that there's a pause. They're going to put you in administrative processing and claim, that they can't approve your visa for some reason or no reason at all. So that's very risky. You're risking not being able to come back. If you file the extension with USCIS, you do get the automatic 240-day additional employment authorization beyond July 31st. After the 240 days, you have to stop working, but you're technically still in a period of authorized stay where you can remain in the US as long as that extension is pending. You may need to consider litigating it. There are a lot of people litigating these issues right now with this benefits pause, and they are successful in those. Courts are finding that USCIS does not have the power to take your money and then not adjudicate your case. So it's likely something that needs to end up in court. But yeah, after the 240 days, you would have to stop working.
How is the trends looking for B2 change of status pending to H1B approval now? This question is coming from Suneed 12394. Not good at all. We are noticing notice of entry denial. We are seeing denials from B2 to H1B when B2 is pending. Not good at all right now.
Let's see. Sabarish Sathavasevan says, my wife received an RFE for the biometric appointment for her H4 EAD. It's been a month since we got the RFE, but have not gotten an appointment for biometrics. What are our options? I would recommend chatting with Emma first to see if they can confirm that a biometrics notice was actually issued and provide you with the details of that. Otherwise, call customer service, try to look into your My USCIS account, because there's generally not seeing that much of a delay from the date of the RFE to the date of the biometrics.
My wife received a biometric appointment for H4 EAD. It's been months since they have received it. What are my options? And EAD is not approved, obviously. Definitely filing a writ of mandamus is definitely a good thing. Stephen Brown from our office takes a couple of people, almost 5 to 7 people every week to the H4 delay litigation. If you want to, you can send an email to info@rnlawgroup.com and we can send the rest of the details to you, how the things work out.
Vital says, which L1B blanket extension is recommended? USCIS in-country or consular processing? If for my clients, if the employee does not need to travel for business, I'm pretty much filing everything with USCIS. It's a pain in the butt because every single one of them is getting an RFE. But I would much rather have you here and working and able to continue working while we deal with the RFE, as long as we filed early, than have you stuck outside the US with a 221G or delays in getting the visa stamp, or some new travel ban happens while you're out. So I'm recommending filing with USCIS, even though it's got its own risks. I think that's much better than having you stuck outside the country.
Well, if the graduate retrogresses, if I lose the job, he's speaking if after filing the 485 adjustment of status, what's the plan? Definitely that's going to be risky for your green card to be approved. The whole presumption is that you got this job offer. That's the reason why they are giving the green card. And then if you lose the job offer, though, definitely that is a risky thing for you to get a green card. But there are some clever, innovative ways. For example, you can be self-employed. And you can be employed with a different company, and you don't have to get the same salary, though. A little bit lesser salary is allowed. So there are some creative ways. Definitely, if you are about to lose the job, I want you to consult an immigration lawyer, because there are options of self-employment and other options, though.
Jesus says, someone on an L1A visa who's reaching the 7-year limit, can they change to an H1B without leaving the US? No, you need to be aware that time spent in L1 counts towards H1B time, and H1B has its own 6-year limit. So if you've already crossed 6 years of L1 time, you've already maxed out your H1B. Even if you have an approved I-140, that is not an option. You won't get the H1B approved at all, let alone consular processing or change of status or anything like that. So you have to make that conversion before you hit 6 years in L time, so that you have enough time left on H1B, and then you can use an I-140 to extend beyond the H1B 6-year limit.
VVM is asking, I heard that in citizenship process, they are revisiting the green card application, revoking the green card. I'm not telling that it's not happening. It's for very rare. For example, I mean, if a marriage is fraudulent and the guy goes to the citizenship, they found out that he got the green card through marriage, they definitely will revoke the green card, though. But it's not for a common person. It's nothing wrong. We haven't seen any green card getting renewed. But if you have some major concerns about your green card applications, where the underlying application, there's something wrong with it, you should consult an immigration lawyer. For a normal people, though, we haven't seen anybody getting green card revoked.
Herday says, I'm working an entry-level job that requires a bachelor's degree on my STEM OPT. The company attorney suggests that my green card application is likely to not get approved. I work as a staff accountant. Is this true? Yeah, it's going to be difficult for your company to make it through the perm process and prove to the Department of Labor that they could not find a qualified, willing, available U.S. worker for the role if the role requires just a bachelor's degree in accounting and no experience, because it's an entry-level position. So you may need to look at changing companies. You may need to look at changing locations, maybe go find a job in a very rural location where there are not a lot of bachelor degree people who are available for staff accounting roles. But yeah, that is accurate.
I have a timeshare with Wyndham. Can I sell my timeshare to somebody else? Is that a problem? I don't see that as a problem. You can sell it. Question from
Monica says,
go ahead.
I'm in my 3rd year of H1B. When is the right time to apply for the green card? Yesterday. Definitely, if you've not started that yet, you're late in the game. It does take about 2 years to successfully make it through labor certification and I-140 right now, and that's assuming everything goes perfectly. So you need to use that extra year that you have to deal with any kind of hiccups, any delays, any issues with prevailing wages, anytime the company has to stop, if there's layoff situations. There's a lot of difficulty with making it through the labor certification process right now. So you need to start as soon as possible.
Vijay is asking this question. Can you throw some light with regards to the self-employment? Can you do an H1B? This is in light of the 485, when the 485 application is pending if you lose the job. I definitely, it's a little bit gray area. I mean, is self-employment allowed? Yes, but it has to be a genuine self-employment. And if that is what they're going to test it more. So I definitely want you to discuss. It's not an option that I want people to pick it up if you get a job offer. Let's say, for example, you're losing the job, you're in 485 application, you have a job with company A, and you are getting a job with company B. I want you to pick company B. Don't go on the self-employment. If ever you want to go on self-employment, there are certain parameters that you have to meet the requirement. Otherwise, you'll be risking the green card. So I want you to personally discuss with an immigration lawyer. So I can't explain all the things. All the situation is based on how your needs are, how the necessity you are in, and what kind of contracts you already may get it immediately so that you can run the payroll on your own self-employment thing.
Bargov says, my H1B was selected in the 2025 lottery and filed for consular processing. It was just approved in March 2026. Currently in the US on STEM OPT, can I transfer to a new employer via change of status? No, you have not actually been counted in the cap yet because your H1B was approved for consular processing. So if you file with a different company right now, they will deny, saying that you are still subject to the cap. You would need to have the company that filed that H1B can file a change of status for you. And then once that's approved, then you're free to transfer to another company.
A question that came from Gayatri is, how soon can you file a H4 if I lose a job on H1B? Well, 1 hour. I mean, you can even file an online H4 application, though. So normally some of the people will just have a consultation with me and then I will help them file online. It takes 1 hour. I mean, half an hour actually, but I added some extra half an hour here and there. I'm working with level 6 position. My company is filing level 4. I don't know what you mean by, we only know level 4, level 3, level 2, level 1. Level 6, is it something your company internal thing? I don't know if that is something your company internal thing. Okay. Applied H1B, H4, and right now H1B is approved. I-94 for H4 has expired. As long as the H4 extension has been filed before the I-94 expiration date, the person is perfectly in legal status. You don't have to do anything for it though, okay?
Syed says, would you advise traveling after filing an I-140? Depends on your status. Number one, we're not really recommending anyone travel right now, especially if you need to go for visa stamping. But the I-140 only impacts certain types of visas and travel. If you have an H1B or an L1, filing an I-140 does not have any impact on your travel ability, but don't travel regardless.
Okay, 1 second. There are so many questions coming in, it's repeated questions that are coming in though. Is it advisable to convert from H4 to F1? If you're wanting to have a OPT and STEM extension, definitely though. But if your spouse already has a I-140 approval, I don't see a need to convert into F1 because F1 OPT and STEM extension has a lot of restrictions. H4 EAD is unlimited work permit, so it's easy to deal with H4 EAD. Submitted 485 application April 29, 2026. What's the timeline for EAD and AP? We have seen people getting 2 months EAD. We have seen people taking up to 8 months to get an EAD. Advanced parole is 2 months to up to 2 years to get it.
R1234 IZE says our priority date is December 1st, 2023. My son turns 21 in December 2026. We filed for L2 extension and change of status to F1. I-94 expires May 17th. Do we need to apply for premium before the I-94 expires, or can I upgrade later? So I'm not sure if you mean premium for the F1 or premium for the L1, L2 extensions that are pending. But with the I-94 currently expiring May 17th, the ability to get the change of status to F1 approved depends on when the program start date is for the F1. If you did it for a fall start date, then you need to get the L2 approved before they can approve the F1. If you requested like a summer start date that's starting in May or something like that, then you could potentially not need the L2 extension approval and just upgrade the F1 to get that approved. It really depends on exactly the scenario there.
I-140 approved with company A, working with company B. And when the priority date becomes current, the company A is willing to file the 485J supplement, file the 485. Can company B also provide supplement J? No, it's not required. Only the company that has an I-140 approval should provide the I-485J at the time of filing the 485. Now, if it's after 6 months filing the I-485J and I-485, company B can provide. But at the time of filing the 485, only the company that has an I-140 approval needs to provide the I-485J. Questions coming with regards to my H1B is already approved before the president proclamation under the council processing. Am I subject to $100,000 fees if I go outside the country? No, since you already got the H1B before the presidential proclamation of the $100,000, you are not subject to $100,000 fees. However, we advise you not to go outside the country. If you are inside the country in a different non-migrant state, instead of you going outside the country getting the stamping, it's better that you transfer the application here in the United States instead of going outside the country.
Alabama Fund says I'm on H1B. My daughter's graduating from high school. She got into a nursing undergraduate program. Can I change my daughter's status to F1? The tuition is the same for in-state and international. I'm assuming that your daughter's on H4 currently. Yeah, you can change her status to F1 for her undergraduate program. Thankfully, the tuition amount is the same. The benefit of doing that is it allows her to do internships, clinical rotations, and those sorts of things that are allowed for someone on F1 that may not be allowed for H4. So you definitely can do that as a change of status in the U.S.
I've heard through McBean Immigration News TV that they're pausing all adjustment of status due to extra vetting, but not officially announced. Is it true, legitimate news? One is she's a very great lawyer. Now, we have seen a day or two getting paused for the adjustment of status, but it is not now. I have seen green card getting approval after April 29th. I've not seen them. I've seen some green card getting approval after April 27th or 29th after that particular day. So it is not official that they have paused it. Definitely, they're still adjudicating applications.
Venka says, will the $100,000 fee remain in effect next year as well? Well, it's anybody's guess. They're supposed to issue a report on that fee within 30 days after the H1B lottery was conducted. We are already more than 30 days after the lottery was conducted, and we don't have any report. I don't know if they're working on it or they're just not publishing it. Nobody knows. They're supposed to decide whether the fee is effective. What are they trying to accomplish? They're trying to accomplish fewer H1Bs. Did it accomplish that? I think so. So they probably will. If I had to guess right now, I would probably bet that yes, they're going to extend it, but it is just a guess.
Ganesh is asking this question. His perm is approved 2 months ago. The company is not proceeding fast to file the I-140. They're not willing to do premium processing. What are my options? Technically none. Only the company, the perm belongs to the company though. So you cannot come to us or go to an independent lawyer. Hey, can you proceed with it? No, absolutely, we cannot do that. Only the company can file it. Only the company can authorize the premium processing.
All
Anything
right.
else?
Well, I
Anju?
think we're out of time today. Thanks everyone for joining us. We'll be back next week on Tuesday at 5 o'clock Central Time with the latest updates, and we'll answer immigration questions live.
Thank you very much.